My name is Michael Morton, and I did 24 years and 7 months to the day in TDC. I was incarcerated for murdering my wife. Just after I left for work one morning, someone came in the back of our house and beat her to death in our bed. I was at work when the body was discovered and the police came to my house, and they never contacted me. They investigated, looked at stuff, did the usual murder scene investigation things, but I've learned since through neighbors who were in the house, and they have told me that in the very first hour, before they did any investigations, before they did any interviews or lab tests, or even spoke to me and informed me of my wife's death, the police were looking around and saying, "Oh, the husband did it, this is easy." And that's how it started. We have general rules, but the criminal justice world is no different than any other bureaucracy in that it's only as good as the people involved. And I think that's one of the reasons in Texas we like to elect our prosecutors, have at least a little bit of control on it. I hired two. They were a team, Bill White and Bill Allison. And at the time, I believe they were co-presidents of the Texas Defense Lawyers Association down in Austin. They were not inexperienced. They were not court-appointed. I spent every dime I had to pay for them. They were good lawyers. I had excellent representation. The reason I was convicted was that the prosecutor intentionally withheld exculpatory evidence. It's been a long time ago, and he says that he doesn't remember. And there are a lot of things I don't remember about back then. But there's a very distinct place in the transcript where the judge asked him straight out just before the trial if he's turned over everything, and he says, "No, sir." And that was simply not true, because just before I got out, the Innocence Project had filed a Texas Open Records Act request with the county and received the file from the sheriff and the prosecutor from back in '86 and '87. That may not have been part of the court record because it was their private stuff, but in it we found all the exculpatory evidence that had not been turned over. And that was a game changer, along with the DNA. My attorneys filed a motion and they sealed the record as far as what the prosecutor had in his file, because it was not allowed into the record, so to speak. I mean, it wasn't public knowledge. They had an in-camera inspection, I guess the best way to frame it. And so that file was sitting up at the Court of Criminal Appeals for a long time. And we actually got them to open it in court, and when they opened it, and it was supposed to be the DA's file on me, this particular part was like 3 to 5 pages. And it was supposed to be in the sheriff's notes and records of this murder investigation. And clearly a 6-week murder investigation is more than just 3 to 5 pages. There were lots of things that were not in there. The records of what the sheriff was doing and what the prosecutor was doing was in their office file. It wasn't in the court record. When a prosecutor lies to a judge about exculpatory evidence, that opens it up to contempt of court. But in Texas, there is a statute of limitations. So I was convicted, and this lie to the judge happened in '87. Well, it's 24 years and 7 months until I get out. So it's a form of immunity until I got out, and the Texas legislature changed the law. Now, the law is different. The clock doesn't start ticking on a contempt charge until the exoneree gets out. Then the 5-year clock starts running. And that's changed a lot. That's really helped everybody on both sides of the bar. Prosecutors now will not even think about jeopardizing their careers or their liberty, their freedom, over a case that's iffy. They won't be tempted to bend the rules or maybe cut corners. And this also makes it good for people who are accused, because Now they're required, the prosecutors are required to turn over exculpatory evidence before the trial, during the trial, and now after the trial. For the prosecutor in my case, while I was in prison, he became a state judge. And he was on the bench when all of this blew up and all of this came out, and there were definite statute of limitation issues. And there was a court of inquiry, which is rather unusual in Texas. But it's a very powerful thing. And at the end of it, there was a plea deal. And what happened to this guy, Judge Ken Anderson, was removed as part of this plea deal. He was removed from the bench. He had his law license taken away forever. He had a $500 fine, 500 hours of community service, and they gave him a 10-day jail sentence. And from what everybody's been telling me and everything I've read, it's the first time a prosecutor has ever done jail time for misconduct in a murder trial, which is a big deal. Now, with the new law, if this had happened now, then any prosecutor who does something like this, they're open to contempt charges, which can carry 15 years in jail. And most felony convictions will be the undoing of a man's or a woman's law license. So that's a powerful incentive. It's a neat thing, and it's reinforcement. When we have a situation like that where it's imbalanced, I mean, the way it used to be, it was as if you're playing cards for money and the prosecutor is dealing. But not only is the prosecutor dealing the cards, he's also looking at the cards and deciding whether or not you should get them. And that's a definite conflict of interest. So he's basically stacking the deck for his own case. When my trial was going on, and there were good days and bad days. It was my first murder trial, so I wasn't exactly at the top of my game. It's emotionally taxing, and it's crippling, and it's a combination of rooting for your team and then gasping when the other side scores. You're all over the map. But because I knew that I was innocent, and I felt that a good deal of what the prosecution was doing was emotional pleas and outlandish accusations and maybe a little character assassination along the way, I had a lot of faith in the jury system and the juries. I figured they would see that, okay, there's really no substance here. At least there's not enough to put somebody in prison for the rest of their lives. And I felt this way because several years before my trial, I'd been called for jury duty, and I'd served on a felony jury. So I know the jury room dynamics. I was on a jury, and we sent a guy away for 35, 45 years. And when it did happen, though, when they sent back the guilty verdict, I was stunned. I almost fell. I dropped back in my chair, because you have to stand when they pronounce judgment, but it floored me. I thought it was going to be a rough trial. It was going to be hard on me, but I figured in the end it would work out. And the guilty verdict was like a physical blow. You're numb and you're hurting. You can't believe it, and yet it's very, very real. It's right there. If a young prosecutor asks me, what can we do? What can I do? What can we? What procedures or acts can we put in place or perform that's going to keep the innocent from being convicted? First and foremost, I think, is transparency and accountability. When you're dealing with criminal trials, I've been told that it's very, very different from a civil trial. Civil attorneys tell me that what they do is put everything on the table and everybody's going to agree, this is what we're going to argue about, this stuff right here. The criminal practice is very, very different. It's a war over discovery. What can you keep hidden? What can you reveal? It just goes back and forth, back and forth. Discovery is huge. If our criminal trials were a little bit more like our civil trials, in that you have everything on the table, this is what we're going to argue about right here, that would change it. Accountability, along with transparency, and even though we have an adversarial system, treating others the way you want to be treated is a really, really good first step. If your case is so weak that you have to cut corners or bend the rules or rely on outrageously emotional pleas to the jury, you may not have a very good case. And the biggest danger of putting the wrong person in prison is perfectly illustrated by me. Because while I was in prison, the guy that really killed my wife killed at least one other woman. And I've gotten the subpoena. I'm going to have to testify at that next trial. And so that's the big danger that every prosecutor wants to avoid. I've even spoken to a prosecutor that told me that he found out that he had the wrong guy in prison, and he jumped in with both feet and helped walk the paperwork through to get the guy out. But transparency and accountability work not just for the prosecution, but for the defense. It has to be a balanced playing field. And when the playing field is balanced, the system works.